The Domestic Violence Act, Part 2, Application for Orders. Section 3, Subsection 1, Power of Court to grant protection order or occupation order. The court may, on application, grant a protection order or occupation order in accordance with this act. 2. An application for an order referred to in subsection 1 may be made a. By the spouse or parent in respect of whom the alleged conduct has been or is likely to be engaged in by the respondent. Okay, so it could be someone complaining against their spouse, or a parent or one of the parents. That seems to be the case. Or B, where the alleged conduct is used or threatened against a child or dependent. So this act, the application can be made by, it can be made by a person with whom the child or dependent normally resides or resides on a regular basis. An application for an order referred to in subsection 1 may be made by, so made by the person who the child is residing in. I guess they're complaining against somebody else committing the act. 2. A parent or guardian of the child or dependent. So the parent or guardian may make the application against somebody else. A dependent who is not mentally disabled. A person who is approved by the minister responsible for social welfare to carry out social welfare work. So that's a social worker. Or it may be made by a constable. Okay. C. A person who is a member of the respondent's household who is in a visiting relationship with the respondent in respect of the alleged conduct engaged in or threatened by the respondent towards that person. Okay. 3. That's subsection 3. An application under subsection 2 may be made on behalf of a person entitled to apply under paragraph A or C of that subsection by A, a constable, or B, any other person, whether or not a member of the household, with the leave of the court. Subsection 4. In determining whether to grant leave under subsection 3b, the court may take into account whether or not A. The application is 1. In accordance with the wishes, or 2. In the best interests of the person entitled to apply, and B. If there is any conflict between the interest of the person seeking leave and the person entitled to apply. Protection orders. Section 4, Application for protection order. Subsection 1. That's application for. Right. An application may be made to the court for a protection order to prohibit the respondent A. from entering or remaining in the household residence of any prescribed person, or B. from entering or remaining in any area specified in the order being an area in which the household resident or of the prescribed person is located. So they could prohibit the person accused from entering the house or from entering within a certain distance from the house. Or C, from entering the place of work or education of any prescribed person. So it keeps them away from the workplace or the school or college or university. D, from entering or remaining in any particular place. Or E, from molesting a prescribed person by 1, watching or besetting the household resident, place of work or education of a prescribed person. 2, following or waylaying the prescribed person in any place. I mean, not to follow them or wait for them to appear. You know that they're going to be walking or driving along a certain route and you wait for them to see them. It prevents the accused from doing that. Alright. Or making persistent telephone calls to a prescribed person. Or 4, using abusive language to or behaving towards a prescribed person in any other manner, which is of such nature and degree as to cause annoyance to or result in ill treatment of the prescribed person. Or 5, demanding any property owned by or available for the use or enjoyment of the prescribed person or any other property in the care or custody of or are situated at the residence of the prescribed person. 2, that's subsection 2. On hearing an application under subsection 1, the court may make a protection order if it is satisfied that A, the respondent has used or threatened to use violence against or cause physical or mental injury to a prescribed person and is likely to do so again. Okay. Or, having regard to all circumstances, the order is necessary for the protection of a prescribed person. 3. A protection order may be made on an ex parte application if the court is satisfied that the delay that would be caused by proceeding on summons would or might result in A, risk to the personal safety of the prescribed person, or B, serious or undue hardship. We're at page 8. Let's once again look at the definitions here. Prescribed person. Ex parte application is made without notice to the respondent. Okay. And then prescribed person means the spouse, parent, child, or dependent of the respondent. That means of the accused, or any person who is a member of the respondent's household or is in a visiting relationship with the respondent. So the prescribed person is the person who the act is being committed against or is alleged to be committed against. Alright, so here now, where were we? Subsection 4, where a protection order. Alright, yes, we looked at that. Subsection 5, in making a protection order under this section or an occupation order under section 7, the court may, at the same time of its own volition, or upon the application of any party applying for the order, make an order in accordance with the provisions of the Maintenance Act for the maintenance of A, any applicant entitled to be maintained by the respondent, or B, any member of the household in respect of whom the applicant is entitled to apply for maintenance as against the respondent. If no such order is maintained, if no such order for maintenance is already in force, provided that the duration for an order for maintenance under this section shall not exceed the duration of the protection order made under this section, or the occupation order made under section 7, as the case may be. We're now at section 5. We will look at section 5 in another video.